Hi, I'm Hall Davidson, and welcome back to KOZE TV's series on Copyright for Educators. Don't forget that these programs, this video and more, is available online at copyrighteducation.org. Also, as you can see, there are quizzes, charts, links, a whole lot of other great stuff that's on that website. So go there, download it. It's there for the purposes of spreading copyright education in the educational community. And if you, for some reason, can't find copyrightheducation.org, try copyrightheducation.info, which is also a URL that links to all the same material. So we like that URL. This show is an overview on copyright. Copyright is a certain kind of a law. If you don't know what copyright is or unclear on what it covers, what it doesn't cover, then this is a program, a 10-minute segment you're going to probably like. Also, you'll end up at the end with more knowledge about copyright than most of your fellow Americans. So let's get started. First of all, copyright law is generally federal. These are federal statutes. They're covered by federal courts. There are some minor copyright laws at the state level, but in general, copyright is federal, which is why so many interesting cases with music and video and websites and chip design and yachts and music end up in the Supreme Court. Great place, and if you go to that page, you'll see lots of links to Supreme Court cases. But that's why so many interesting things happen at the Supreme Court, is because copyright law is fundamentally federal. The reason it's fundamentally federal is that it is given that designation in the Constitution. That's right. Copyright is as old as the Constitution itself. And I love this document. I've been to Philadelphia. I've seen it under glass. It's a terrific piece of work. These guys, at the age of enlightenment, invented a country. And here's the document they did it with. A country that works pretty well. So here it is. And on this front page, here's where copyright is born. This section says Congress shall have the power to grant to authors and inventors rights for a limited time to their own work. But that's not the key part. The key part is the very beginning that you can just see here. And it says to promote the progress of science and useful arts. Those artists, those authors, those inventors are given exclusive rights to their work. Not for their benefit, but to promote the progress of science and useful arts. So what does science mean? Well, here's a good definition of science. It came out of my daughter's school dictionary. It's a Merriam-Webster dictionary. And here's the first definition. The state of knowing. It's knowledge. Science in the late 1700s meant learning, meant all knowledge. So when the Constitution says that intellectual property was born to promote the progress of science, they're talking about promoting what you do every day, and that's education. You take misunderstanding and ignorance, and you change it into understanding and knowledge. And copyright then was created really to make your job easier. So anytime there's a dissonance between you're wanting to use intellectual property to teach and the law, it's an irony, because that's why it was invented, why intellectual property came into being. There's always been a big debate about whether we need copyright protection for creation. There is a school of people that says without copyright protection, you'll get no artistic work. You'll get no great art. But remember that Shakespeare was before copyright protection, Beethoven before. Even in the current age, live television wasn't covered under copyright. And that was sort of the golden age of television. So there's also an argument to be said that copyright isn't necessary for artists to create things, but to promote the progress of science and the useful arts, the founders of the Constitution thought it was a good idea, and that's why it's in the Constitution. So, love that part of it. Something else that's good to know is that copyright is one of the sections of intellectual property law. It's not the only one, and I'll just mention the others just so you know they exist. Patents is one. Trademarks is another. Trade secrets kind of fall in there too, but the big ones are patents, trademarks, and copyright. So let's look just briefly at what these mean. Trademarks, you probably know, things like Coca-Cola, a trademark. You see trademarks every day. Surf City, I think this is kind of fun, is a trademark now of Huntington Beach, California, which is where the studios of KOCE-TV are located. So Surf City can only be used by one city, and it was a big debate in the courts. Who is the true Surf City? Turns out it's Huntington Beach. Another thing that's interesting about trademarks is you have to make sure it is protected. Xerox is a trademark for a photocopy company, photocopy process. It's Xerox. So there was a time when Xerox was starting to become synonymous with a photocopy. Hey, Xerox this for me, or in a window of a store there'd be something that said Xerox copies for whatever price. Well, Xerox had people go around and say, if you don't have a Xerox machine, a Xerox brand machine in your copy shop, you cannot say Xerox copies, because they're not Xerox copies, they're Canon copies, or they're Fuji copies, or whatever they were. So you have to protect trademarks. Otherwise, like other things, Kleenex, Band-Aids, it might disappear into common parlance. Okay, so that's trademarks. Let's look at another one, patents. Patents are interesting because you hear about them every day, and they're also a driving force in the economies of technology. One of the big ones, TiVo. TiVo recently won their patent battle. It turned out that they could patent their process, even though there are a lot of other digital recorders around, because they were the first ones to be able to record and watch at the same time. The ability to, pause, rewind, watch a previous segment while it still continues to record. That was the basis of their patent, and they won that, which was very important for that company. Another patent case that was recently in the courts was BlackBerry. BlackBerry, those great little devices that people love and carry around, had a technology involved that another company had patented, and they settled out of court, but it looked like the feeling was that that patent was going to be valid and that BlackBerry would have then had to pay a great deal of money. BlackBerry's not the name of the company, but that's the name of the device. Another interesting patent case, I think, is that Alexander Graham Bell and Elisha Gray both had patent applications for the telephone. Alexander Graham Bell, on January the 14th, 1876, got his into the into the patent office by noon, beating Elisha Gray by 2 hours. That's why, among other things, Alexander Graham Bell got the patent for the first telephone. Beat him by 2 hours to the office. Now, Elisha Gray later went on with partners to found Western Electric. They certainly stayed in the telecommunications business, but interesting case. You've got to get there first. You've got to follow the rules. Anyway, that's patent law. All right, but we're talking about copyright. Copyright really has much more day-to-day applications in the educational environment. What is a copyright? What can be copyrighted? Well, anything created that can be put in a fixed form can be copyrighted. Here's the actual language of the law. Original works of authorship fixed in any tangible medium. And that means something that you can read and fix in a machine that is invented now or maybe invented in the future. Any future method of fixing things that is putting in a tangible form that you can make then a copy of is what determines what a copyright is. So that's what it is. That means that when you do a lesson, if you put it on a piece of paper or design a website, is that copyrighted? Yes. If you've designed a website, that's been copyrighted by you. It's automatic now. So the creation of intellectual property in a fixed form is what a copyright is all about. And you've created intellectual property. You've created copyrightable material probably every day if you're an educator. So what can a copyrighted work consist of? Well, all the stuff that you see in front of me. Words, numbers, notes, all that stuff can be put in a fixed form and therefore can be copyrighted. So that's just to say that nearly everything can be copyrighted. So you have to be careful. The Hollywood sign is copyrighted. There are images, architectural images that are copyrighted. Parts of Disneyland, for example, are copyrighted. Just the picture of them, the image of it, is copyrighted, so you can't use it. The good thing about all of this for education is one area, education and the free press, two areas, that you don't have to worry quite so much about having material fall into your classroom instruction. Remember, there's a reason for copyright, and it's to help education. So a lot of these little details and the craziness of what you're doing isn't important because you're at work and your job is education. So that's good to remember. Let's look at something else. You can't copyright ideas, just so you know, and you can't copyright titles, which is why sometimes you have two titles that are of very different things. So ideas are not copyrightable. So you may think, oh, I have this great idea, I'm going to copyright it, nobody else can do it. Not correct. Copyright, when you have a copyright, gives you under the law some exclusive rights. So when you see a work, a book, a movie that's been copyrighted, anything in fixed form, a sculpture, an image, a writing, a song, all those things, these are what the copyright holder has exclusive rights to control. One, reproduction, whether it gets copied or not. When videos appear on a site like YouTube, if they haven't been authorized, then you can bet that a letter will come to YouTube that says, please take that off, and that video will disappear. But again, that letter has to come because the copyright holder does have the exclusive right for reproduction. All right, also derivative works. If something is based on a work, it means that the copyright owner still has control of it. Many people think, oh, I'll just alter it a little bit, then it's my design, not their design. But that's not always the case because the copyright holder does control derivative works. Also distribution. Copyrights can determine how the copyright holder, whether material is distributed or not and how it's distributed. Also, copyright holders control the transfer of ownership, public performance, and public display. So these are what's covered under the law by copyright. These are important to know only because when you leave the educational environment, these things all come into play. Okay, more information about that on the website. Now, if information is, if all those things are copyrightable, then what's not copyrightable? Well, it turns out just about everything is. This was a fun case. In Britain, a man on his music CD put in silence. He put in silence as one of the cuts on the record, on the CD. Turned out someone else had already done that, an artist named John Cage, and had copyrighted silence. So this person, when they went to court, lost because silence on a record had already been copyrighted. So this person decided he was going to do a different version of silence, not a derivative version, a whole new version of silence, and put that in his project. And here it is. I bought it on iTunes. 1 minute of silence from Project Grudge. And the original work was, I think, more than 4 minutes. So the new artist said his work was superior because he was able to condense it down to a smaller size. Anyway, I actually went online, bought a minute of silence, which I now have on my iPod. So you can buy silence. So anything seems to be copyrightable as long as it's in a fixed format. Okay, so this is Nothing, the visual equivalent of silence, and now KOC-TV has copyrighted that. So there we go. Let's look some more next at fair use, because all the things we've talked about for copyright have an exemption. There's limitations on those exclusive rights that you saw for education, and that's what we're going to talk about next. It's called fair use, Section 107 of the Copyright Act. We hope you'll stay tuned for that. Fair use, and thank you for watching.